So the topic, as you are aware, that it is the investigative powers of a magistrate under inquisitorial and adversarial system. So one pattern which I have followed in this short talk is that I will be primarily focusing on the new criminal laws which has been introduced from 1st of July 2024. And also I will be focusing a parameter to understand that what is this change between the inquisitorial system of justice and adversarial form of justice. Now, to briefly explain that, we have to first understand that what is adversarial form of justice and what is inquisitorial uh, form of justice. And I have knowingly placed a question mark that what India follows. So, in an adversarial form of justice, we believe that it is a search for the truth, and that search for the truth is that open competition between the prosecution and the defense. I always explain this with an example that it is a form of a cricket match, that where the batsman and the bowler will be there, and there has to be a judge who is a neutral, and in this system, it is the judge who selects that what qualifies as the piece of evidence. But in case of an inquisitorial system, what happens, the extensive investigation and examination of the evidence is also done to find out the truth, but there the judge has certain discretion to accept what qualifies as the evidence and what does not. So the trial judge determines what witnesses to be called for and what witnesses to be called for in what manner and order. However, in the adversarial, the parties, which is the prosecution and the defense, what they do, they get the opportunity to present their claim, negate the claim of the opposite side, and the only job of the court is to oversee the process and whether the process is a particular judicial process or not. So that is why we say that in adversarial system, it is the law of precedent which primarily follows, which primarily binds. But in inquisitorial system, the judges are free to pass the decision only following the statute. So less use of judicial precedents are there. And so by the last two examples, we can say that lawyers' role is very much active in adversarial because the prosecution and the defense is there. However, in the inquisitorial, it is passive because the judge also has the power to put questions directly to the parties from time to time. And that is why it is the judge in adversarial system which has to understand whether that particular evidence is qualified or not. And we cannot say that the power of the judge is also discretionary in the adversarial. Why? Because it is not wide. The law of evidence is there, which is the Bharatiya Shakha Adhinayam now, and on basis of that, the judge can decide the evidence can be qualified or not. And but in inquisitorial, it is the judges which have a wide discretionary power. The last example which I would like to tell is that the countries like Germany, France, Italy, and various others are inquisitorial form. These are mainly the civil law countries, whereas adversarial system is US, UK, Canada. India, I will not answer now. I'll leave it at the last during the question answer to be discussed. Now, what India did, India made an overall change in its 3 criminal laws, which you are all aware. I am not going into those things. So, but this change in the criminal laws happened when? Was the laws which we had did not work, was not working? What was the issue? So far we were having episodic reforms in criminal justice system through the acts of criminal amendment acts like 1983, 2005, 2008, 2013 and 2018. But is it that the law was not working? Because some concerns, in spite of the amendments were there, is that 72% of the total prison population in India are under trial prisoners. And you are seeing that Supreme Court time and again, I can give you two quick examples. Calcutta High Court released in 2022 to a person from correctional home in West Bengal after 41 years as an under trial when he had developed neurological issues. There was a person in the death row. It was discovered that when he committed the crime, 28 years he was in death row. It was discovered after that 28 years long time that he was a juvenile when he had committed the crime. Numerous examples are there, and these are very recent. I'll go ahead. So whether the new laws are now designed to consider an issue of under trial prisoners, we cannot also forget that today the CGI also have said that there are huge pendency of cases. There are false cases also, so it also becomes difficult from the courts at time to deliver the justice very quickly on time. So that is why 3.4 crore criminal cases are pending in India. The figure is of July because it is rising because of the new law. I have used the figures of July. And cases which are pending for more than 5 years constitute 69% of 3.4 crore cases in India. So this makes the prison population 122% of the total prison population which is there in India. For example, a room of 100 people, we have made to fit 122 people in that room. And that is where 6.1% of the in-service police force are only trained. I am not saying this. It is the India Justice Report, Crime in India report, Prison Statistics of India report. These reports are saying. What we do in criminal law, the problem where it occurs, that we read criminal law very theoretically. Yes, theories are very important. With my professors, I really accept it is important, but we cannot forget the numbers. India does not have a victimization survey, so we don't know, or qualitative survey, so we don't know how the cases have targeted qualitative them. In only quantified study in form of the Crime in India reports, NCRB reports. From there we can understand these numbers, but these numbers is only of the numbers of the reported cases, not of those cases which never got reported due to many factors. Now, let me slowly go into the new law, where there I will be connecting with the role of the magistracy, as I have termed it as. So, BNS have done one good thing by including one new chapter as chapter 5, where we talk about the offences against women and child. So, chapter 5 really talks on that. So, entire chapter, the offences were all spread out. So, it has been codified in chapter 5. Thereafter, the child, so that definition of the child has made uniform. There was an exception in the offense of rape, that rape, the wife when below 16 years is not rape. So that 16, so everywhere the definition of child has been changed to 18, and that decision of the Supreme Court decision of independent thought decision has also been respected by the use of section 2 subclause 3 DNS 2023, which defines child. Section 2 subclause 10 includes that we should recognize it's high time another gender, the transgender. So it has been included as a third gender. I am aware of the discussions which is rightly going on in US that we have only two genders, and where India have gone ahead to introduce the third gender, which is the transgender also. Now coming to the procedural part slowly of the BNSS, the notable changes which they have done is that audio video electronic means, they have defined what is audio video electronic means. I'll talk about during the procedural part more. So where they say that the purposes of video conferencing, recording of processes, identification, search, seizure, transmission of evidence, all to be carried out through electronic means. Are we aware that the CRPC never defined what is bail? We only said that when bail can be given, what situation, non-bailable, bailable, all that we said. But for the first time, they defined bail. That bail means a release of a person from the custody of the law and put on the custody of the surety. That means what? The court puts certain conditions. And that is why we have first time defined bail, bond and bond. Musanara Khatun versus State of Bihar. 1979 Supreme Court had said that in the jails of Bihar, the people were languishing for more than the time if they were convicted. For example, the offense of theft is of 3 years and they were in jail for 5 years as UTPs or under trial. So they said that they can be released on personal bond. So we took some 40 odd more years to incorporate that definition, so that the PNSS have done so. So that has defined bail bond means an undertaking for the release with surety, whereas bond is the personal bond or an undertaking for the release without surety. So bail, bond and bond has been first time defined. Electronic communication, what is that? So they have said that anything verbal, pictorial information, video content transmitted, transferred with the help of mobile, wireless, computer, etc., all to be electronic communication, because the police officers or the law enforcement officers are free to use this now. They have changed the definition of the victim also. We'll talk about that on the rights of the victim at the last part, but to tell you that there was no definition of victim till 2008. 2008 Criminal Law Amendment Act inserted section 2 WWA. That means what? Crime is there. So victim is thought as a thing which may happen or which always will happen. But 2008 2WA defined victim. But the problem was there, one sentence was there where the accused has been charged. Now shall we wait to confer the victim status, which will confer the victim rights, and then will give the rights of the victim? So no, now the BNSS have omitted the accused has been charged. So that word has been omitted from the definition in the new definition, which is section 2Y. So all we are aware that the first case under BNS was happened in New Delhi railway station, where one hawker was illegally occupying the public thoroughfare. So that is the first case under BNS. Now I have explained the concept of adversarial and inquisitorial, and then I will draw this example when talking about the role of magistrates. Now see, the role of magistrates becomes very important, because what happens, magistrates, they are a judicial oversee into the acts of the stakeholders of the criminal justice system. So what I have done, I have tried to divide the first role of the magistrate into 3 parts or 3 gates. The gate 1 is the lodging of the crime, which is the FIR. So preliminary inquiry. So they have said that in section 173. So 154 of FIR is now 173. So there will be a preliminary inquiry. That preliminary inquiry, they have given a strict jacketed timeline to the police for all offences which are punishable with 3 to 7 years. And that preliminary inquiry can continue till 14 days. Now, what did Lalita Kumari say? So from here, I draw what Supreme Court said in Lalita Kumari. Lalita Kumari said that preliminary inquiry can be only done for matrimonial offences, communal offences, medical negligence cases, corruption, and when there is a delay in reporting of the crime from the date of incident. However, the new law have said that no, there can be 14 days preliminary inquiry for offences between 3 to 7 years, which is said to be the magistrate's role, one of the important roles. So the new law also did one thing, that the EFIR or that zero FIR we have heard sometime. I would like to clarify one thing, that zero FIR is not only for women, anyone can file a zero FIR, but now the law have made it statutory also. So the wordings of 173 would tell you, irrespective of the place of commission of the offense. So where it says that you inform the police through electronic means, and the police have to get your signature. So you have to come within 3 days from the sending the information to the police. If you don't come there cannot be any action, because please recollect, after this session, please open a model form of a FIR or your criminal manual and see on the right hand side bottom there is a signature of the informant. So that signature of the informant cannot be there if you do not come to the police after sending the information of the crime to the police within 3 days. So this is gate one. So under gate one, two hurdles has been already installed by the new law where the common man may face a difficulty to approach the gates of the criminal justice system. So the second role of the magistrate was 156(3) in FIR, where or the court complaint case we used to say usually, so which is now 175 subclause 3. Very good. Now in this situation, what happens? That notice to police about non-registration and hearing of the police is one condition which has been given. Previously, the magistrate could have ordered the investigation directly, but now the magistrate also has a uh, obligation to hear the police why they have not registered the case, and that hearing of the police will not be automatic. A notice has to go, there has to be a compliance, so it will take some time. So another hurdle which could be that the person who is trying to approach to the police is unable to do so again because of this situation. Now, after that, the magistrate can order for investigation. I'm not saying no on that, but that procedure also has been stated in 175 plus 3. Now they've inserted a new section 175 plus 4, which was not there in your CRPC. Now we all remember about section 166A and B. So 166A is that when public servant is supposed to do any lawful act, is not doing that act. Now to draw this thing, I would like to highlight Supreme Court in Shashikant versus CBI and Rajendra Singh Katoch versus Chandigarh administration. It said that the police have the inherent power to make a preliminary inquiry before registration of FIR without fixing a timeline. So that was the situation. And after that, Bhajan Lal said what? That in a complaint, when it is clear and unambiguous, the police are under a mandate to register an FIR in all cases of a cognizable offence. So, Criminal Law Amendment Act 13 inserted section 166A and B, non-treatment of victims and public servant not doing a lawful act, which is also a offence they have stated. Now, when you have introduced protection for public servant, what is that? There cannot be any automatic FIR for public servant now if public servants are involved in commission of crimes or they have not done any lawful activity which they are supposed to do. Because 175 subclause 4 says that if in case of any complaint the alleged public servant involved has to be heard along with a report from the senior officer has to be received by the magistrate under 175 subclause 4, only then there can be registration of the FIR under 175. So there also you are able to see there is an hindrance. And what is the second thing happened? So by this 166A and 166B is almost ineffective now. So in every situation you have to show cause that why they were not involved and things forth. Only then the case can come up before the magistrate. The next gate to approach the criminal justice system is the complaint case. So section 223, which was section 200 of your CRPC. So what they have done, they have installed two things. One is that there cannot be automatic cognizance. Previously, when a complaint case used to be filed, there could be an automatic cognizance taken. But now a pre-cognizance hearing, which judges and few others, we academicians are also trying to term it as de novo trial, where a mini trial, a possibility of mini trial is there upon the pre-cognizance notice. And no timeline is installed that within how much time this pre-cognizance notice or stage has to be completed. So this makes it rather more difficult for the common man to approach the justice system. And that pre-cognizance notice, the accused will try to take much time possible and try to bring much things possible, and without commencement of the case, without cognizance we all know it is the judicial notice of the case. So first time which the court takes into account. So without that, we are in a situation of a possibility of a small trial like things to happen. And along with that, there is 223 subclause 2, which again gives public servant a protection from non-registration of cases against them. So again, the same procedure of 175 has to be repeated, that a report has to be called for from the C superior and the alleged public servant to be heard, then only the case to be filed. So this is what the three gates by which we can approach the criminal justice system, and there are some hurdles which has been installed by them. And I have compared it on the light of these three important cases about the registration of FIR. Now, if I go specifically more in details about the role of magistrates, first is that in regard to arrest of person. So now there cannot be any arrest in less than 3 years of an infirm person or a person who is above 60. So less than in an offense which is less than 3 years, an infirm person or a person above 60 cannot be arrested, and that can be done with the permission of the DYSP. Arnesh Kumar versus State of Bihar, 2014, Supreme Court said what? That for all offences we have to issue notices. So up to 7 years, Supreme Court have said. So the new law have done one good thing, is that 35 subclause 3 have not put any restriction of 7 years or something. Now for every case, because up to 7 years we know that these are magistrate tribal offences, whereas above 7 years we are aware that these are session tribal offences. So for that we can say that they have made it uniform. But 2 days back Supreme Court have said on 27th January that 35 subclause 3 notices cannot be served through electronic means. One thing which all the three laws have done is the introduction of the electronic means throughout the three laws. But here the Supreme Court 2 days back have said that no, you cannot send those 35(3) subclause notices. Appearance 41A is now 35 subclause 3 through WhatsApp or electronic means. It has to be served like usually it was served previously through posts. Now they have done one good thing, that DK Basu versus State of West Bengal. I am sure you have all read, where the Supreme Court 1997 had said that the information of arrest to be maintained in every police station as well as district headquarters. So what they have done, they have said that every police station will have a designated officer to do that, and arrest not only to be maintained in physical format but also in digital mode. So the police websites, district headquarters police website should also give us the details of the arrests. And if there is an arrest outside the jurisdiction, both the jurisdictional police website should show about that arrest. To do what? Students, to do what? To ensure a situation of non-repetence of Neelavati Behra versus State of Orissa, 1993 Supreme Court. What happened quickly, if I can tell you in 10 seconds, is that the mother Neelavati was there in the house, and when police had come, picked up his son and went away. The mother was not informed why his son was picked up, which police officers, which police station, why he has been picked up. After 2 days, the body of the son was found in the railway track. And the mother wrote a letter to the Supreme Court, and Supreme Court started an inquiry. So the doctors went there and saw that due to a train accident, the body was found in the railway tracks. The police claimed that at wee hours of night, he escaped from the police station and the approaching train crushed him. And that is the situation which the doctor says that no, the injuries not only is of the train accident, but also physical other kind of torture is also there. Also, the body was found in a handcuffed situation. So this makes so to ensure that these situations don't happen, we have said that arrest outside jurisdiction to be also maintained in digital mode. So not to repeat situations like this. The arrest how made. And just to recollect, Arnesh Kumar versus State of Bihar Supreme Court also said that it is the role of magistrates to oversee the entire judicial process which has been by the police officers. And if they do not do, there can be departmental action taken against the magistrates also. So this is one of the very important thing which the Arnesh Kumar judgment does. So arrest how made. So what they do have done now, that now we can again use handcuffs. So Supreme Court time and again NHRC have said that these are the against the fundamental rights or human rights. But they have said that we can put handcuffs on repeat and habitual offender or the person who is about to escape from the custody of the police. Now the problem would happen is that it would become very difficult to establish a situation that in that situation when suddenly a person is apprehended that he is repeat offender or habitual offender, so so or he tried to escape. So because these are the only justifiable grounds for putting handcuffs, and those are also limited to certain categories of offences in section 43 subclause 3 of BNSS, like offences against children, drugs, all these offences are there. So it becomes very difficult later on if they claim that they were put handcuffs illegally. But two very important thing or very positive changes which the court have done is that, see, the magistrate can now also receive an prayer from the police, that from section 86 and 107 are the two new sections which has been introduced. See, 86 says that police can now request the start of process of identification of properties. Sometimes the police only investigates, but in a financial crime or a crime which generates revenue, we are unable to do anything to the property or the things which are there. So what happens? What happens is that the police can now give a prayer to start the process of identification of that property. The police can give a prayer for attachment of the property during the investigation to CGM for proceeds of crime. So attachment for forfeiture can now start from the pre-trial stage. So if we think that the role of magistrate, as I have said, that it starts from the registration of case, and in every state the new law have introduced that these are the things which has to be placed from time to time. Summons also, it is the job of the magisterial court now to keep a register which will contain the email ID and the phone number and etc. by which the summons can be also now sent electronically. So it also becomes one of the role of the magistrate while service of summons. The service of summons, section 94, is the power of the police. For example, the police calls someone to some document. So it means that if we have anything in the phone as an image or an email, the police can want it. So that is also electronic communication within the definition, as I have told you all. One very important thing which the new law have done is the introduction of 105 BNSS. 105 BNSS is that as Anesh Kumar said, that it is the role of the magistrate to check the compliance of arrest memo, seizure list, medical report, and other things where the police reports the case before the magistrate. Now the magistrate also has to check the search and seizure audio video recording. So in every search and seizure, there has to be audio video recording through electronic means, and it has to be sent without delay to the JM, judicial magistrate, SDM, or the DM, as the case may be. Also, what it says that before entering, if the room has to be searched, before entering, the audio video camera has to be switched on. Thereafter, after entering the room, if anything is picked up, for example, this phone is picked up. So this phone has picked up, the video has to show that the phone is picked up. So this is one important aspect which the new law have said. So what it will do, it will help the innocent prove its innocence, that the video, it is not searched from me or seized from me, and it will also ensure better conviction. Thereafter, we go that the that while the investigation is on. So the first 3 points I have already explained in the gates to approach the justice system. So now, while the investigation is on, what is the next role? So 174 subclause 1, it says that the daily diary report is the station diary in every police station. So that has to be sent to the magistrate every fortnightly. Every 14 days, that if the police is not starting a case after preliminary inquiry of 14 days, or what the police did after 14 days, it is a cross check by the magistrate to oversee what the police did after that power has been envisaged in the case. So it is another very important role. But for that, that general diary entry, that thing has to be digitalized. Many states, I think Karnataka has already done it. Andhra Pradesh, many other states have done. West Bengal is on the verge to do it. So 176. Also incorporates a very interesting thing, is that now they have brought in the use of forensic science. So 176 subclause 3, they have said that forensic science experts has to visit the crime scene for every offences which are punishable with 7 years or more. And not only that, the videography of that process of the visit has to be also kept for the trial. But there is no guideline on the timeline of the reports. Also, the states has been given 5 years to implement it. But in the July, in 4-5 months back, when the law was implemented in July, the central government gave some 2,200 crores to start several forensic science laboratories across India. So that is one positive thing which has happened. Another thing is that who cannot be called to the police station. We have always difficulty in understanding this. So now 179 BNSS have made it clarified. It is also the role of the magistrate to observe that whether it has been followed by the police or not. So male person below 15 years, above 60 years, any women or anyone who is mentally or physically disabled person, or someone who is having acute illness cannot be called to the police station. Cannot be called is the exception is what? Accused is the exception. Accused can be called. But these persons who are witnesses, or if the accused says that they are my friends and etc., or they are my accomplice, so they cannot be called. But they can also be called if they wish to. So they said that if they wish to, they can be called, but otherwise the police cannot call them. Now, 161 statements, what happens, the police, which is 180 statements, 180 section, that audio, video, electronic means it has to be recorded. So which is one very important thing which can be done. So 183 is about the recording of the statements of the witnesses of the offence punishable with 10 years or life or death. So the court cannot refuse. Magistrate court, which is another important role, cannot refuse to record the statement of witnesses which the police bring for offences with 10 years or more punishable. Now you must have read the next provision that police custody has increased. Yes, police custody has increased, but 187 BNSS says that 40 days is for cases where charge sheet to be submitted within 60 days, 60 days for cases where charge sheet to be submitted within 90 days. But Supreme Court recently, I think this month only, have said that the police custody has to be the initial 40 days only. And the old law also said not beyond 15 days. So here also not beyond 15 days we have kept unchanged. So it is not that entire consecutively he can be kept. So entire 40 days he can be, but if he goes back to judicial custody, that time from the police custody has to be subtracted. For example, initial 7 days he got police custody. We have said, so Supreme Court have also clarified it is the first 40 days. So out of 40 days, 37 days is already gone. So 33 days are left. Now he has not been granted police custody but granted judicial custody. So maybe 10 days is granted. So that means that 10 days is also subtracted from 40 days. So 17 days, 7 plus 10 has to be subtracted from 40 days, and only then further police custody can be considered by the magistrate, which is another important aspect. Thereafter, the completion of the investigation is the charge sheet. Charge sheet is section 193, which was 173. Interestingly, they have said that victim has to be informed about the progress of investigation, which I will deal at the last stage. So within 90 days, the victim has to be also informed about the progress of the investigation. Charge sheet can be submitted electronically, and there can be also further investigation during the time of the charge sheet. Whether it will improve cognizance, which time can only tell. Now, if we come to the specific role of the court in the magistrate domain, the first thing is the introduction of Section 20. Section 20 is the Directorate of Prosecution. They are talking about the Directorate of Prosecution was already established in Section 25A of CRPC, but they have added 4 subclauses 7, 8, 9, 10 to Section 20 now. So they are advising to formulate District Directorate of Prosecution. So what it says that there can be a deputy director, there can be a director, deputy director and assistant director. So that deputy director, what he will do, that he will scrutinize police report and monitor cases between 7 to 10 years for speedy disposal. The director will monitor cases for 10 years or more. An assistant director below 7 years. They will also give opinion on filing of appeals and pendency of cases to the magistrates. So this would come a sort of a legal opinion, legal advice, not only for the magistrate but also for the police, that they are going in the wrong direction or something like that. So that could be a sort if it introduces, because the opening line of section 20, it says that the state may establish. Okay, so because it also new laws also require huge expenditure, because the infrastructure also has to be built, unless that it cannot be done. So the power of the court, when we talk with reference to the magistral power, is that they have changed the sentencing powers. So the first jail can give a fine of 50,000 and a community service now. Say we introduce another form of community service in section 4A of the BNS 2023, only for 6 category of offences. One is the offence of theft, defamation. So all these are the few offences where the community service is introduced. But what is community service? It is not the explanation in the law which is given. It is that for the benefit of the community only. So the second jail can have also the fine amount has been increased to from 5,000 to 10,000. So this is the new power of the magistrate. Forms of summons, as I have told you, it has to be, the court has to maintain a register to do that, and every adult member of the family can also be served with the summons. Previously, only adult male member of the family could be served with the summons, but that male word has been removed by BNSS. So this also makes us that sanction, we also read at times that sanction to be given. So sanction, the prosecution of judges and public servants, they have said that maximum time is 120 days for the government to say that whether sanction will be there or not. If not, there has to be within 120 days. Within 120 days, the sanction has to be deemed to be sanctioned. I hope the slides are changing. Am I audible?
Yes, sir, you're audible.
Slide is visible to you, right?
Yes, sir, now it's visible.
Okay. So in regard to sanction, it is the 120 days timeline, which is the maximum timeline or the deemed sanction, which is understood by the new law. If the government is saying no, it has to say no. If it is not saying anything, it is deemed sanction. And the new law also in the entire magistrate trial have introduced one thing is that they have introduced timeline. But mind you, there is no timeline for the completion of trial still. But they have installed timeline at various junctures. For example, that the commitment of cases from magistrate to session has to be done within 90 days to a maximum of 120 days. So 90 days to a maximum of 120 days. Then section 230, supply of copies. You know that before beginning of the trial, which is one of the principle of fair trial, the magistrate has to ensure that supply of copy has to be done. So within 14 days from the date of appearance or production of the accused, means either the police arrests him and produces, or he comes and appears before and asks for bail, so that right will operate. So within 14 days from the date of appearance or production of the accused, the copy has to be supplied. Also victims, if they are represented. Further, in magistrate trial, the discharge of the accused person under 262 has to be done within 60 days from the date of committal, and the accused can be present through audio video means also. Framing of charge to be done within 60 days from the first hearing of the charge. The presence of the accused can be now done in electronic means in session cases only. However, section 350 will tell that all trials to be done in electronic means only. Prosecution evidence, magistrate trial also can now allow the deposition of the public servant also through audio video means, but not by the witnesses of the defense. So only of the witnesses of the prosecution and not of the defense it can allow. So magistrate trial is a much better position right now. In case of judgment, within 45 days the judgment has to be produced. Magistrates will also ask that not more than 2 adjournments can be granted, and that to be granted after hearing the reasons of adjournments of the other party. So 346 2b will tell you that magistrate can also pass an order which says that an handwriting specimen can be given without the person being arrested, because as you know that it is an exception to article 20 self-incrimination, Selvi versus state of Karnataka, that the person cannot be need not be arrested to get the specimen signature or the handwriting. Also the new law, what it has done, it has introduced one aspect of in absentia trial. For example, for the proclaimed offender, I agree that many countries they say that it cannot be done. Rather, it is against the principle of fair trial or it against the principle of human rights. But let us see the process first. So 90 days has to be elapsed from the framing of charge. Then 2 warrant of arrest has to be issued in an interval of 30 days, which is 60 days. There has to be newspaper advertisements about the trial being commenced and non-appearance of the accused. There has to be also information given to the local places where the accused last resided. There has to be also information in the court where the trial has been commenced of the in absentia trial. There has to be videography of the trial, and also no appeal can be preferred after 3 years. So the Bharatiya Sakha Adhiniyam has also said that the evidence is given against the person who is absent in the trial will go in against him. He cannot come and say later that he was not there, the evidences were allowed. He was not given even the right of cross-examination. If he has to come, if he wants to cross-examine, he have to come during the trial. And no appeal from that order after 3 years. Yes, I am agreeing with the fact that Only if he is able to apprehend, we can enforce the sentence. I am accepting that. So this was magistrate trial in cases of warrant procedure. But there is other procedure, that cases which are other than police report or complaint cases. So you all know that. So section 269 is that. So they have introduced two changes in that, 269 and 272. So magistrate to proceed with the case if the witness not to be found for cross examination as if not available. So he can proceed as if the witness are not available, to save the time of the court, to save the time from false cases. Also, if the complainant is absent, 30 days time will be given. After that, the case can be also dismissed in cases or complaint cases. Further, there has to be cases which are not warrant, which are some summary trial, which are summons cases. They have increased the timeline from trying all cases summarily. That means the amount, if the theft is up to 20,000, dwelling house, if the theft by clerk is up to the value of 20,000, so BNS 303, 5 and 6 can also be tried summarily. Also summons cases, I just explained that there has to be 30 days time can be given, and if the accusations are groundless or it is baseless, it can be discharged the accused person. Now, general principles of trial, the magistrate also has to oversee that in withdrawal of proceedings, in section 321 CRPC, now 360, victim has to be given an opportunity of being heard. So that is one important thing which has to be understood by the magistrate. Next important role of magistrate towards under trial prisoners is that 436A was added because of Hussainara Khatun, Justice State of Bihar, that they can be released if half of the sentence, if they have, one third of the sentences, if they have completed. So now what the new law have done in 479, that if it is first time offender, they can be released if they have completed one third. Other cases, it is half. If they have completed for which they are accused of, they can be released. Multiple cases not allowed. Jail super has to send a mandatory report now, who has completed one third, who has completed one half, to the DLSA for compliance of this. However, the new law could not implement the witness protection scheme and have asked again the states to enact the scheme. You know the best bakery case, you know several cases the Supreme Court said that witness protection is very important. And also, another important aspect in regard to magistrate power during trial is that 497, that if any perishable property or which can be decayed naturally, if it is found by the investigating agency within 14 days, it has to be placed before the magistrate. The magistrate can order for disposal, destruction, confiscation, delivery upon videos and photos to be kept for the trial at later point of time. So this is another thing, and I have already told you that section 530, that entire proceedings can be done in electronic mode now. So that general section of 530 is there. Thereafter, plea bargaining, they have also made it timeline. So within 30 days from the framing of charge, one has to decide they are going for plea bargaining or not. 60 days time will be given for the mutually agreed application. First time offender, 1/4 punishment can be given. Where not released under admonition, probation, first time offender, 1/4 can be given. Otherwise, 1/6. And the repeal clause is that there has to be all the pending things, the trial, inquiry, investigation, anything which are pending, it will be governed by the CRPC. There was a huge confusion which we were attending several training programs where we have clarified that no, for example, if the offense has committed in May 2024 about a terrorist act, which is a new offense under BNS, or that organized crime, or something else which is a new offense 69 of BNS. So this cannot be a crime, or an FIR cannot be started from 1st July for the crime which they have done preceding it. So that is part which cannot be done, which we have explained. Now, coming to the last part of the talk, which is the rights of the victim. So, victimology is still growing. I would rather say it is still growing. The new law has incorporated some aspect, and there is a long way to go for that. So, we were expecting that Section 2WA, which is the definition of victim, now 2Y, it could also incorporate the definition of UN Declaration for Basic Principles of Justice for Victims and Abuse of Power 1985, but it could not do so. Also 338 subclause 2, where it says that the evidence which is placed by the victim's advocate, as the victim's advocate can be engaged under section 18 subclause 8, it has to function within the parameter of prosecution. So they have to only submit written notes of arguments after the stage of evidence is closed. But Ashish Mishra versus Jagjit Singh have said between paragraphs 20 and 24, April 2022 Supreme Court, that the victim has a long or has a right to say at every stage of trial, but that was not incorporated. Then 173 subclause 2, we knew that a free copy of the FIR to be given to complainant. Now the word victim has been installed. So 176, the victim of rape, the statement to be recorded only at her residence. Medical examination of the rape victim. Now within 7 days, the doctor has to give the report to the investigating officer. Also, victim has to be informed about the progress of investigation within 90 days. But what information, that has not been clarified. Magistrates are there, has to look forward that how that has to be implemented. 230, I had already said that victim if representation. So that victim representation would be a key issue now. And and the next part is the pre-bargaining. I have already stated that victim's role in the pre-bargaining has one of the important aspects, that the timeline has to be monitored by the court, and that court not to be open for the offenses of rape and POXO. So there was one incident during COVID in Ara district of Bihar, that one person had come, the rape survivor had come to record her statement, and she was assisted by two persons from NGO known as the caregivers. So what they did, so they the victim wanted the statement to be read by them. Court said no. Victim thought that victim will not know what will happen to them. Victim fell unconscious. Court thought it is contempt, and contempt of proceedings started against the victim and the NGO person, and they were sent to jail on that situation. So still, the court not to be opened is only for offences of rape and POXO and not other offences. Section 3227 CRPC was then not implemented. Now it is 366. Whereas victim compensation scheme, you are all aware, 357A, now 396. There also what happened, there the NALSA guidelines of April 2018 for women survivors and victims of crime, those principles is not incorporated still. Also, the fine in addition to compensation is only for offences of acid attack, rape, and gang rape, not for other offences. Also, treatment is only for offences of uh, uh, acid attack and POXO. Thereafter, victims' right to appeal, it should be also incorporated the complainant's right to appeal, which was stated by the Mallikarjun Kodagil Date versus State of Karnataka, which was also not there. So I say thank you, and I would like to also come back to the question that what India follows. So whether any student would like to tell that which system the India follows, I think I have tried to explain the role of magistrate in India primarily, and before that I had tried to distinguish between the two systems which is followed across the globe. So India follows what, I would leave the question to that, and I will answer it if I am. So anyone would like to write anything in the chat box that India follows which system? Any student?
Sorry, adversarial system of
Adversarial
See,
system.
sir will tell you better that
Should I
that
continue?
in law profession the ability to speak is the most important thing, and I was rather very grateful that in my initial days I could, one of my professors was sir, and I could learn from him this aspect, that ability to convey the message. So India follows an adversarial system of justice. It is a system where the judge monitors the trial and is the prosecution and the evidence, which is like a cricket match. I always say that they are batting or bowling, and judge is behaving like the umpire. They are given their choice to bring which bowler to bowl, which batsman to bat first. So, like there, they also are allowed to bring which witness first and which witnesses later. So, India follows a adversarial system of justice like USA and USA. But India also has few principles of inquisitorial system, like giving the victim some amount of representation, victim compensation, or witness protection. Without that, we cannot say that a strict adversarial system of justice, if followed, can work better. So I say thank you, and if there is any question, I can take it up. Thank you for the opportunity, sir. I'm really grateful, sir. Thank you very much.
Anybody has any questions? Please. If you have understood something, you should ask questions.
Sir always used to say that.
Anybody? I saw somebody writing there. Now not visible. Yes, Nandini.
Yes, sir. I don't think there are any questions. Should we move to vote?
Yeah. Okay, fine.
Okay, sir. It is my privilege to deliver the vote of thanks for this memorable occasion. I, Nandini, on behalf of CMR University School of Legal Studies and the entire fraternity of our institute, extend my heartfelt gratitude to our esteemed speaker, Dr. Surja Kanta Baladhikari, sir, Assistant Professor NUJS. Today's guest lecture on investigative powers of the magistrate under inquisitorial and adversarial system has been incredibly insightful and thought-provoking. Sir, your profound insights and analysis of magistrate powers has been very enriching. Thank you, sir, for sharing your vast knowledge and experience with us. Your words have undoubtedly left us a lasting impact and will serve as a guiding light as we navigate our academic and professional journey. We're deeply grateful to our Dean, Professor Dr. T.R. Subramania, sir, for his unwavering support and inspiring words of encouragement, which helps us to reach heights. Sir, your able guidance and vision continues to inspire us to strive for excellence. Thank you, sir, for your kindness, interest, and support. I would like to extend our heartfelt thanks to our well-wisher, Director Professor Dr. Vijay Praneshwaran, sir, for his invaluable vision and commitment which makes opportunities like this possible. A special note of gratitude to our faculty coordinator, Ms. Nirmala Harish Ma'am, for her valuable guidance, encouragement, and contribution that have played an integral role in the success of today's event. Not the least, I thank my friends and fellow students for their enthusiastic participation and cooperation. To conclude, I would like to quote Benjamin Franklin: an investment in knowledge pays the best interest. Thank you all once again for being a part of this session. Thank you, sir.
Thank you so much, sir,
Yeah.
for having me.
Thank you very much.
Thank you.